I'm going to do a little trending title traps, which is going to kind of piggyback off of Jeff's claims portion. So you might see a little overlap. I'll kind of blow through the overlap, and we can kind of talk about. Basically, what I wanted to do is kind of give you a little bit of our war stories from that we've kind of been spinning along a little bit, sprinkling along a little bit of the way. But we used to do this. This section was just complete foreclosures, which I found completely. I think I'm just sick of them, maybe, so I wanted to change it. Maybe we can go back. On your questionnaire, let me know if you want to go back to foreclosures. So we talk about this a lot. I think Adam hit on it, Jeff hit on it, jurat versus acknowledgement. So I'm not really going to touch on it again. But we had a statute, then we had Mitt Romney did what they call an executive order on notaries, but it wasn't law, it's just an executive order. But last year in January, the statute adopted that executive order. So right now we actually have statutory forms of what to use. So these are the statutory forms of what to use. The statute just says similar thereto. So we can kind of get around it if we're missing this and that. I'm not going to get around it if I'm missing my most important thing, like voluntary for its stated purpose. And on my oath, I'm not going to get around it if it doesn't say sworn affirmed. I can take other words. So sometimes, Jeff and I talked a little bit about this. Again, any affidavits, trustee certs, pains and penalty of perjury, jurat. Any other document, acknowledgement. But I've seen some certificates that you would want to have a jurat that says in the beginning, I certify or I swear or I under oath. I might live with it. In general, the one exception to that rule is the entry. We pretty hold tight on that entry because that's a second means of foreclosing, and all you have to do is record that piece of paper after entering with two witnesses. Record the piece of paper that you did it, and you wait 3 years. So it's a really big deal because you're wiping out junior lien. So that is like I kind of want it perfect. But all these other ones I kind of, finagle a little bit. We have what's called a curative statute, which is 18324, which says after 10 years, these notary and authority and signing issues are gone away. Just basically authority for corporations and signing and whatnot, and any mistakes in notaries. I'll even take it for a completely missing notary.
Oh, I would.
Yeah. So it's not going to fix grant problems, POA problems, that kind of, but I would take it for if you had a jurat instead of and vice versa. Okay. Jeff did this as well, the power of attorney. Okay. So the grant clause is just the principal. Do not include any of the other attorney in fact. Don't mention it ever, ever, ever. Remember, the owner has to sell the property. The agent is just signing on behalf of the owner. So the owner has given the agent the authority to sell, and now he's selling. But the actual seller is the person that owns the property. So, and then you want to make sure that the person that appeared before you was the agent, the attorney in fact, because that's who's literally appearing before you. I had a law school professor say his number one rule was never notarize a document that there's not standing in front of you. Right now, we don't do electronic notaries. Electronic notaries. Some other states have adopted it. We have not yet.
Skype notary, right?
Yeah. So don't, again, when Adam said if you're doing a closing, refi, I'm just going to bring the package home. Sam, Sarah, it's fine. I'll just bring it signed tomorrow. They still need to be notarized. So that would be me notarizing his signature without him being in front of me.
Certain states do allow that now, right?
Yes, but we don't.
Notary? Yeah.
And if it gets really complicated, though, when your boss wants you to do it. So often, if you're representing sellers, you will meet the sellers to sign the deed, right? You'll meet the sellers to sign a POA. The POA is being given to you, so you can sign the closing documents for them. Often, lawyers will have a separate sheet having the sellers put in their social security numbers and make the statements that I'm going to be making. So they're telling me, yeah, go ahead, I didn't have any mechanics lien, or yeah, I didn't, no one's living there. Giving me these statements so then when I sign it at Adam's office, I'm covered. But technically, the notary statute says you can't notarize a document that you're named in, right? So here I am having the seller sign the deed, I'm having to sign a power of attorney, I go back to my office and tell my paralegal to notarize it, or tell you to notarize it. Don't do it. And the way you're not going to do it is because the statute says you can't notarize a document that you're named in unless you're an attorney of the state.
And not to be crazy with a practice story, I had to abandon ship out of a law firm.
Oh yeah, you didn't mention this.
I need to do the war story this time. I had to abandon ship out of my old law firm because my boss's son went to federal prison for mortgage rescue schemes, and my boss has, after multiple years of litigation, been disbarred by the Mass Bar Association. Being a young lawyer, I was 6 months into my practice, and they're like, no, this is okay. This is just, it's a gray area. Don't worry. And I was like, well, that seems like a bad place to be for a lawyer. And they're like, don't worry. And clearly my spidey senses were right. Luckily I didn't do anything and didn't get in trouble, but what they were doing was illegal eventually. And so you can get put in a bad spot. You can get pressure. If you're a solo practitioner, a lot of times you do feel the pressure of like, well, I got to make money. I got to cut the corner to make this work because I got to pay my mortgage. But man, you can get sanctioned, disbarred, or like in that case, federal prison.
Didn't you have the FBI, was that come to your office or call you?
Yeah. Thanks for the stories. But yeah.
These are good. You need to, right?
No. I literally had left. Was deposed by the AG, and then 2 days in the federal building in Boston by the FBI. It was mortgage. It was mail fraud. It was all these other crimes. But as a kid right out of college, a kid from Peabody who doesn't have significant family wealth, this was like rocked my world. So it was one of those things where it's like I don't know. My boss said, but for the Mass Bar Association, my boss said is not a valid defense against doing something that is incorrect.
Okay.
So.
Forms of granted acknowledgement. So basically, again, the person that owns the property or the entity that owns the property has to sell the property. That's your grantor. Whether it's a corporation, an LLC, a trustee of a trust, or an individual. That's your grantor. Not the president or vice president of Fidelity Finance. It's Fidelity National Finance. So the way they took title has to be the way they come out. If Sarah Supple, vice president of Fidelity National Finance, was the grantee, is that how I bought? It might as well just say Sarah Supple loves the Red Sox. Like after that comma, it doesn't matter what you...
MCLE.
Yeah, Queen of MCLE. It doesn't matter what you put after that comma. I own it individually. So if you have a deed into the vice president of IBM, that guy owns it individually, and that's who has to sell.
This actually happens a lot with condos when people don't know how to do condos or don't know how to do corporations.
We just looked at one.
Yeah.
You see it all the time, and I'm actually seeing it even now.
So all the deeds are wrong because it was actually went into Tom Jones, manager of LLC, and then all the deeds came out of the LLC, but Tom Jones was the person who actually owned the property.
In the Supreme Court, it was basically said that a corporation's an it. It's a person. It's its own entity. So it's not all the people under it and the shareholders. It's an it. It's not a they, it's an it. So that's who we want to make sure. Again, we see it all the time. And you don't want to be the one that makes that mistake because, again, you have to go back to your client and say, well, you bought this 3-family. I did condo docs and converted to 3 units. And then I sold them. Well, come to find out, you didn't own it, the corporation did, and I had you sign all the wrong way. Can you do it again? I mean, you don't want to do it, right? So just remember that. The flip side is the trustees own the real estate, not the trust. This can be different by state, but in Massachusetts, trusts cannot hold real estate. It has to be a trustee. So if I have a deed into a trust without a named trustee, that deed is void, unless I can fix it under one of the REBA standards, which is 40, I don't remember. Trustees have to hold real estate. There is one kind of Crocker's footnote, where even Mass Business Trust needs to have the trustee, but a trust association for a subdivision, there's a note that says if there's a deed or a covenant into the association of a subdivision, it's as if all the members are the holder. So that's the only kind of loophole I find. Other than that, we want the trustee to sell, trustee to buy, make sure it's the trustee, not the actual trust that's holding. We'll see, like, into the Sarah Supple Realty Trust, Sarah Supple as trustee. I'll take it. Don't love it, but I'll take it.
What happens if the trustee signs or forgets to put as trustee?
So I'm okay with that. Again, my biggest thing is the grant clause. I can give a little more mobility and movement on the signature line and the signature block, the notary block. Sorry, the signature block and the notary. If it's in the back chain, if you called me now, I'd say fix it. Call the seller's attorney, ask them if they can write in trustee. You know, we can handwrite some stuff. If it's old enough, again, if it's over 10 years, I have my curative statute. Don't care, but it's the grant clause that's the most important. We can be a little wiggle room on the other stuff. Jeff had mentioned the Kaufman case, which is basically said, I think it was about litigation. They held as trustee, they sued individually or vice versa, you know, but we apply it, the rule kind of, Kaufman rule is you're conveying in the capacity of what you own. So if you actually owned as an individual, because you put it in, take it out to refinance, put it in, take it out, like you'll see a lot of this. If you own as an individual, but my deed says Sarah Supple trustee, Kaufman's going to say that's okay, because it's still me, right? However, there's what we call reverse Kaufman, where I own as trustee, and then I sell individually. And you would think this doesn't happen. It happens a lot. Again, mostly because sometimes I think that they forget that they put it in trust. They did this estate planning. They wasn't sure what they were signing in Adam's office, that a deed was actually going on record, you know. So you see this happen.
Or they just think that they are the be-all, end-all. It's my trust.
It's my trust. I am, yeah. So, I don't know, 50-50 on who takes reverse Kaufman?
Well, I mean, reverse Kaufman doesn't work, but, you know, it's my
See,
opinion.
so we can tell who's the 50-50. There's a couple small court cases. I think I have a bankruptcy one and maybe that will honor reverse Kaufman, but it's not enough yet. So that's one of the things that you call, and I'll say, well, how old is it? I might insure it, but then I might tell you I'm not going to undertake to fix it. I'll keep insuring it down the line, which I like to call kick that can. I'll kick the can, but just let your buyer know if he has a really pain in the tough purchaser when he goes to sell, it could be a problem. And we can talk about the risk in that when we get there. We talked this a little bit at Secretary of State's, as Adam loves the Delaware LLCs and the Delaware Business Trust and the Delaware, what's the other one? The Laird
It's
Series.
Series LLC.
We don't have that in Massachusetts.
No. But don't be afraid that these Delaware Series LLCs will buy property in Massachusetts, and this legal entity doesn't exist here, and we're all kind of like, what do we do? A little over-lawyering sometimes. But if I have a foreign LLC that owns real estate, now again, they do not need to be a corporation in Massachusetts to buy real estate.
They do need to be registered here to file litigation, though.
Yes, they can't sue, and also to sell. So the problem we have is this. Here's my title standard. That a conveyance of real estate in Massachusetts by a limited liability company or a foreign liability to a BFP by a person identified as a manager or person authorized, execute, deliver, record, blah, 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 filed in the office of the Massachusetts Secretary of States. So Adam's bank counsel, he calls me up. He's like, Sarah, I have this Delaware LLC as my seller. Great. They need to file here in Massachusetts to sell. You know why? You cannot tell from the Delaware's website who has authority. They will not issue any certificate. It's completely hidden. You cannot find out. That's why they want to do it. You cannot find out who has authority to sign. From a risk standpoint, one of my biggest things is who has authority to sign, right? Otherwise, I'm waiting 10 years. So the only way to do it is file here in Massachusetts, name a person that's authorized to sign, either a manager or someone designated as a real estate signer. There's 2 different boxes. So they could designate Adam to sign real estate docs. I don't care who they designate. It doesn't have to be a manager. They can leave managers blank. They just have to designate someone that can sign, and then we can take. And I think it's a $500 filing fee, and they can do it online. So a couple times I've had banks who work in other states that do these witness-only closings, and their clients are in, Israel. And so they come to Mass, and they're like, I do this all the time. I just close over online. I say, well, we don't do that in Mass. Well, it's an LLC, and I just want to I'll go to the embassy and I go, just go to the Secretary of State and add somebody that's local. Your attorney or your accountant or whoever that you can trust that to sign your real estate documents, okay? Very important. Some of us, I don't know, Jeff, you can chime in here. Some of us, there's certain home states, I think Connecticut might be one of them. New Hampshire's not, Delaware's not, whatever. Say Arizona. They have, their Secretary of State has an animal that will issue a certificate that tell me who is authorized to sign. If that home state does that, I'm inclined to take it. I don't make them file here as a foreign. But I'm telling you, I've had it turned down by 2 other underwriters. Because what happens is sellers, you'll call me, say you're representing a seller, and you say, Sarah, my seller's in Arizona LLC. Great. Does your home state give you a certificate that says who's the managers can sign? Yeah. I say you're fine. Well, a month goes by and you go to closing and there's the buyer's attorney who doesn't write with me, or Jeff, writes with the title company that says you're not fine. You know, technically you're not under the standard and under our statute. But, so those are the little things that you kind of, but if you called me, I'll tell you that. I'll say I'm okay with it. Most of us are okay with it. Some of the baby companies, not so much.
The crazy thing I've seen is company is like that. Company owns real estate and everything else, and through the SEC, company sells all of its shares in the company to another company, but there's nothing of record to say that this Nevada company now owns Company B, and then Company B then deeds it out, or something else happens. You know, it's really
it's complicated. So there's a whole, and we get into this a little bit when we talk about discharges and mortgages, because we have a statute that basically says that you can rely on assignment or a discharge if there's a succession. So a formerly known as, or a now known as, or bought all the assets. But what you can't, like successor by merger, if the companies merge. So you can go check, right? You can go check on the Secretary of State's or the banker's FDIC or whatever. What we won't take is successor and interest, because what that means is they bought some of the assets, maybe not all, but maybe all, but there was no actual merge there, and so we need an assignment, or we need a new deed of whatever assets. I've run into this. I have like a very old 1960s corporation. They've sat on this building for years, and there's a lot of succession, and so they just want to give me a 5B of who and who is what. So we're going back and New York State records, filing cards, and all the crazy stuff to try to find it, but it's complicated. So my rule away, don't over lawyer. You know, if you truly want to hide somebody, if you do want to do the Delaware LLC and your client really wants to do that, make sure they tell them if you buy an asset here in Massachusetts, you may be required to file as a foreign LLC here in order to sell your asset. Liens.
If they have a Delaware LLC that owns some big property, $500 is not that much.
No, right. Yeah, exactly. They don't like, yeah. Liens. Okay. Mass health liens. I mentioned them before. They might be one of my least favorite animals. Because they're usually a lot of money. What this means is Mass Health had to come in and pay for the nursing home or whatever medical care or hospice for the person that owned the property or had a life estate. So it gets a little complicated. We have, when you file a probate, every time you have to do a certain probate or you have to do a description of heirs, you have to notice Mass Health. And they are litigious like crazy. They do not back down. Again, people that we don't like to be afraid of. So we had a situation where son and mom owned property together as joint tenants. There was an execution against mom. So that's a levy. We have now case law that says this would not turn out the way it would now because we have new case law, but back then this is how it was. An execution severed the tenancy, so there was tenants in common. Well, the agent didn't know that, or the title examiner didn't pick it up. It got missed. The son sold the property thinking he was the sole owner. He wasn't. So, okay, fine. Son goes to sell the property a year later, then they find out, or someone buys it, they go to sell it a year later, then we see the claim. So we get the claim. So what do? Easy. He was the only heir. We file a probate for mom. Let's determine he's the only heir, and then poof, the deed magically is good again, right? Because what he only has half interest, we're missing mom's interest, but after a filing of a probate, he's the only heir. He's him. He signed the deed. We're great. Well, we had to notice Mass Health. So, $300,000 lien. Now, you can negotiate with them. Apparently, they'll take 50% of proceeds. So we have claims, litigation, blah, 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 blah. But the Mass Health is serious. We also have two statutes in the probate, which is 20220, which is 1-year creditor claims, date of death, and then 20220A, which is administration claims, that's 6 years from bond. So when I die, my devisee, if I have a will, my heirs if I don't, inherit title vests in them upon my death, subject to a couple things. Divestment from a PR's power of sale, if I have a will, subject to divestment from a creditor's claims, and subject to divestment by an administration claims. So no one's going to take title from me until that 6 years is up, right? Because why would you buy a title from me if my administration claims can divest you? Well, they expire 6 years, except for Mass Health. So make sure, if we're not anything kind of a license to sell or a PR's power of sale, any of these claims, including Mass Health, would attach to the proceeds, not the property. But not if you're taking from the devisee or the heir.
If there is a lien from EMA, that's going to show up in the title search?
Yes, if the question is if there is a lien, it will show up in the probate, sometimes at the registry. Always in the probate. It will be.
If there wasn't a probate,
If there wasn't a probate, then Mass Health doesn't know they died, and then there's no issue. But if there's not a probate, I can't take title from anybody anyway.
until you die?
No. Nope. They have to be noticed. I mean, unless they're reading the obituaries.
If memory serves, I think too, just as a practice point, the release from the Mass Health, I believe it's like a
Oh, yeah.
it's a fax now.
It's like a closing letter.
Unnotarized letter.
Yeah, yeah.
Yeah, because I've had that panic before. Like, I just get an email of a document. I'm like, just to record this.
Well, and the DOR is doing that as well.
Yeah.
So
yes, Department of Revenue. That's what they.
Jeff mentioned an M792. So a 792 is a federal form, an M792 is a mass form, and basically that was releases of estate taxes. So when you die, you have an inchoate lien against your property. Nothing is recorded, but there's a lien that exists for estate taxes. So every time there's a death in your exam, you're going to look for an affidavit under a statute that says that I was the PR or I'm the person in possession of the property, and they did not have to, his estate didn't necessitate a mass or federal filing. But if it did require a filing, then you're going to look for a release. And that's used to be in the form of a 792 or an M792. Well, now the feds and now Mass have decided they don't like that. They just call it closing letters. It's basically like a letter that says nothing's owed, which is hard to get unrecorded, which is why we usually file them with the probate. But the statute says it has to be recorded. So then you get another title company saying, Sarah, you have to indemnify because it's not recorded. And I said, the probate's part of the title. And then we just fight. But, so there's the Mass Health, which is basically like Medicaid, Medicare, like the nursing home, those kind of fees. And then there's there's estate taxes. So the statute basically doesn't say that estate taxes are owed. It just says that you don't have to file. So you may have to file and not owe anything, but if you have to file, then I need a release. Make sense? Okay. Executions. The big little title trap on this one, we have an attachment, we have an execution. So if someone files a lawsuit against you. At the very beginning of the lawsuit, they're going to get they want to get an attachment. They want to attach all the property you own in this county. So you can't get rid of it while our lawsuit goes on. So an attachment's pre-judgment when the lawsuit starts. If you win your lawsuit, then you can get an execution. And that execution is property specific. So that you're going to pick one of those assets in all over the county, and you're going to levy it. So you're going to record that execution. You have 20 years to record the execution, but once you record it, you have 6. 6 years to have the sheriff do a sale, or it expires. REBA has added 90 days onto that because of the filing fees for litigation, but in general, 6 years.
They also have 90 days to record the deed, so they could do their sheriff's sale in the last day of
And
that
then record the
6
deed.
years.
Which is why they're 90 days. So you call me and you say, Sarah, I have this guy, he's selling a property, there's an execution against him, it's still good, it hasn't expired. Also, by the way, they can bring it forward. So they can keep bringing it forward as long as they bring it forward before my 6 years expires. And I said, okay, are we paying it at closing? They're like, yeah, we're going to pay it at closing. I said, okay, here's the thing. Treat it like a lender payoff in the sense that you want a formal payoff from the attorney or the creditor. And then you have to get it released. The statute says the creditor can release it, the sheriff, okay, or the court in the sense that they can find the original execution, mark it paid in full, take it to the court gives you a clerk's certificate, says marked paid in full, then you record. The attachment statute lets the attorney of record discharge, but not an execution because that's an actual levy. So if you're paying it off at closing, I want you to tell who's taking that original execution, if they have it, and taking it to the court and getting that clerk's certificate. Who's going to do it? And if you have to do it, maybe you want to charge for it. And how you're going to get it. If it's the creditor, good luck getting Bank of America to sign a release. Because let me tell you, I need authority for that person signing it at a release for an execution. So it's either the president and treasurer of Bank of America, which I'm telling you right now you're never going to get, or a clerk certificate or a vote. So it's a lot. So if you're paying it off on closing, just remember, ding, 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 Sarah said I had to do some kind of more on this. An attachment, I'll take from an attorney. Federal tax liens, there's certain liens that attach to after acquired property. Remember when Jeff was talking about that woman that worked for the law firm that owned all that real estate because she was the straw person? One of the probably reasons why she was also probably a good straw person, she probably had a really good credit. Because if you use a straw person that has a federal tax lien, even if it's on record for a second, that attaches to your house now. Because it attaches to post-acquired property. So you'll run your buyers. Your buyers could, I don't know if you've run into this yet. Yeah, so your buyers didn't pay their, usually it's small business employment taxes is what I see most of them for, sadly. Yeah, so there could be they own nothing, but the Fed's like, only cost me $75, I might as well record it and stuff, I can see if I hit anything, like kind of throwing things. And then they go to buy, that lien will attach to the property that you bought after. There is some wording on whether your mortgage is, whether it's subordinate, purchase money is subordinate, blah, blah, blah. But you call me. You also wonder, if they have a $50,000 lien, how'd they have credit to get a loan? But,
I've had one where we're at the table up in Essex County, and I don't know if the government knew what they were doing, but while we were at the table signing the deed to the new buyer, the feds put a tax lien against the seller. And it was just like, it's unbelievable. We were like there at 9, they went on at 9:15.
Yeah.
The examiner came over and said, hey, just so you know, and obviously caused a delay and everything else, but man, I was like, they just got it on in time.
They do that. Child support liens. Here's the little title trap on this one. It's 10 years from, so again, it's after acquired property, but it's 10 years from perfection, okay? Perfection, so child support lien is on record. It's not 10 years from recording. So I owe child support. The lien's been on record for 5 years. Then I buy. The clock starts ticking from perfection, which is when I bought. Okay? So not from when recording. Little title loophole there. Bankruptcy. My favorite. If the case is dismissed, it's like it never happened. You can ignore. If the case is discharged, we want you to wait till it's closed before you can sell. Think about it this way. If the case is dismissed, this means discharged. There's a typo right there. The discharge in bankruptcy discharges the obligation to pay the debt. It does not discharge the liens on record. Now, seems a little silly because if you don't have to pay the debt, why wouldn't the lien go away? You either have to get an order free and clear, or you have to get a motion to avoid a lien. So I had a client call me, and she said, Sarah, I have a title, and I have a dismissal. Bankruptcy case is closed, but I have an execution on record. And I said, well, the bankruptcy attorney should have told you that even though your obligation to pay that creditor is dismissed, not the lien. And of course, they were the bankruptcy attorney. So I had a little foot and mouth there. Like, you did a very bad job. But what she ended up doing is faxing like Citibank or whatever and saying, can you give me a release? You're in violation of the bankruptcy order if you don't release because the obligation to pay is gone. And they did. So we got it. But just know that. Don't, because a bankruptcy case has been dismissed and closed, doesn't mean what's on record is gone, unless you have an order free and clear or a specific motion to avoid. The big other thing with this judgments from the court, 14 days appeal period. And I still to this day see every single order free and clear signed by the judge states the appeal period is waived. We are of the school of thought that the judge cannot constitutionally waive an appeal period. So we will not. None of us will. No title company will. That's pretty hard and fast. This is just basically the case that confirmed what I just told you. The other note, little title trap again, here's my order avoiding liens. Okay, so you can see here's a Citibank, FII card, they're recorded. And it says, declares that the liens covering the interest in exempt property are avoided in their entirety. Yay! Read the last sentence. The avoided liens shall be reinstated if the case is dismissed unless the court subsequently orders otherwise. What? Like that, to me, does it, like from a risk perspective, okay, so they're avoided, but if say they're on a payment plan, say that he doesn't follow through or whoop, they're back. So now you have execution, then your mortgage, which thinks they're in first position, right? So this is when you call me. I've seen a couple. I had one of these on top of my order free and clear. Doesn't seem right, because if you have an order free and clear, it's really free and clear. But then I didn't know, and so I sent it to we have in-house claims counsel. And again, as we talked about, the bankruptcy court is very finicky. So when I have some of these, sometimes I run it by them as the litigators, and they gave me some very good case law where I was okay on this one because I had my order free and clear.
And most of my associates will bring unusual title problems to me, and even if I know the answer, I'll still say call Sarah and verify so that at least I know you're on notice of that funky issue,
yeah.
And I have protection.
Well, remember studying for the bar exam, like they used to tell you, you need to know a little bit about a lot of things. That's me. I know just enough about every little single subject to know where I can find out more. And we have 12 other attorneys. We have sister counsel. We have litigate. We have Westlaw. We have Crocker's notes. And I mean, we have it all. So even if I don't know the answer, which is very rare, I know everything, I could go find it for you in a short period of time. Conveyancing to estate planning, trust, and LLCs. If you're going to do this for any of your clients, if you're going to help them with a will or transfer property to a trust or put in an LLC, make sure you're not voiding their owner's policy, okay? Because some policies do not cover post-policy transfer to a separate entity. Some do, but you want to call us and you want to ask.
In that case, wouldn't I call you and ask for the change endorsement?
We do a
talked about?
change endorsement,
Yeah.
okay? Maybe I charge nothing, maybe I charge out of $100, depending on my mood. Yeah, so you just want to make sure, okay? If you are going to do estate planning in your firm, and they come in for estate planning, and you say, hey, do you have an owner's policy? They're like, I don't know, I bought in 1982. You're like, let me sell it for you. You can sell them an owner's, right? Make some money. Okay, you have to do a title search, blah, 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 but you know.
It's just issue.
Yeah. Trust certs. Okay, this is a little bit of bane of my existence. So there's two types of trust certificates. I wish when they had created the statute they would have called it something else. But we had the 2008?
I thought it was
11?
further back.
All right, let's say 2000, whatever. So before then, you had to record the entire trust, whether it be a revocable, irrevocable, nominee. We can do a whole class on trusts. You had to record it. It was like $100 for the first 5 pages, 25, it was kind of insane. But then we had a statute that says, you know what, why do we make you record some of these Q-tip trusts? I don't know if you've ever seen them, but they're intense, and they have sub-trusts, so a lot of people say, well, we'll just have a realty trust or a nominee trust, or what we call a non-denominative trust, like a title holding trust. So even then you might not want to record the whole thing, so we have a statute that says you can record a trustee cert, a certificate of trust, and here it is, 18435. A certificate sworn as stated and executed on the pains and penalty of perjury signed by the person of the records, so it has to be someone that of record is the trustee, certifies that the identity of the trustees, the authority of the trustee to act, or the existence of the facts constitute condition precedent, blah, blah, blah. So this way, it's a certificate signed under the pains and penalty of perjury with a jurat that says, I'm the trustee, here's my successors, this is what I can do, and you can rely on this, and then I don't have to record a cert. One page. Great. That's the certificate of trust under the statute. Here's a little sample from REBA. Name, authority to act with all real estate, no facts other that you should all know about, pains and penalty. If the 18435 certificate is the authority to sell, you don't need another thing. You don't need anything, right? If the one on record says that Sarah Supple trustee can sell the property, then Sarah Supple trustee can sell the property. You don't have to ask anybody else. It's done. Sometimes people get backup belt and suspenders, but that's who you need the trustee for. Name the successors.
I was going to say that's the biggest thing I see is that the form that she just put up there, some of the pieces of that are not there. And then trustee passes away, and it's like, well, where's the original trust? Try to figure out who has the authority to do what.
Because remember, trustees hold the real estate, not the trust, right? So Sarah Supple's trustee of the trust. I go to you guys, one of you, to do my certificate of trust, and you don't name a successor. I'm not going to say that's a level of malpractice, but I'm just saying, I die, there's no one holding my real estate now, and you have to go to court to get a new of me appointed. That's not fun, right? Like, why did I go to you to hire you if my kid now, after I dead, has to go back to court and hire someone else? So you want to name successors. You want to name me, my husband, my aunt, my uncle, and any partner at the law firm of blah, blah, blah. You know, I don't care. Give me as many as I can do, so in case somebody dies, that I have someone to take title from, so you don't end up back in court.
And registered land requires you to have a formal resignation, or they have to prove that you're dead to get the successor to be able to have authority.
Yes. The other type of trustee cert is what I call, some would call it the classic, the OG, before the statute, is a nominee trustee certificate. So before the statute, you had to record the entire nominee trust or the entire realty trust. A basic nominee trust or a standard nominee trust says the trustees cannot act unless they're directed by the beneficiaries. Okay, great. Fine. Trustee goes to sell, and you're like, well, you can't sell to me until you're directed by the benefit. How do I know that happened? So most of the trustees, it sounds a little self-serving, but most of the trustees say us third parties can rely on a certificate signed by the trustee that they've been thereby directed by the beneficiaries. Okay? So it's going to say, it's going to say, the undersigned have full power and has been directed by the beneficiaries to enter into the purchase, sale, mortgage with blah, blah, blah for this amount, for this amount, for this amount. Okay? That's a nominee trustee cert. Also pains and penalty of perjury, also have a jurat. But it's separate from the one under the statute. Does that make sense?
Who signs that?
The trustee. Yeah. And really, technically, only if your trust says that we can rely on this trustee certificate. Most all of them do. If it's a revocable trust and the trustee has the power to revoke and terminate, then I'm a little more, then they could probably do whatever they want, right? Because they could have terminated and gave it to themselves. So we'll get into a little bit of that self-dealing situation too.
I've actually seen attorneys not know what they're doing.
Oh, this is why I brought it up.
And record the wrong thing
one.
multiple times.
Multiple times.
So they're basically establishing the trust over and over, meaning to do something else though.
Yes. And the statute, basically, you're only as good as your most recent 18435 trustee cert. So you can update it, but so every time you do it, you're unwinding what's used to be. So that's where it can cause problem. That's why it was one of my traps. Just know what you're doing and know what you need. And if you don't know, call me or call one of your other underwriters or ask, I think part of the problem too is if you're a solo practitioner or you're in a firm where you're the only one that does real estate, like I was, the only person I could go to, even if it wasn't a title question, was me at the time, just to bounce ideas off of. And we're okay, Jeff, probably 50% of my phone calls is title issues. The other half is like, what do I do when I have this, this, and this? It's just because we see it.
Yeah.
And we see it much more.
A lot of what we do is we confirm what you're calling about anyway.
Yeah,
It's
yeah.
a certain amount of that.
You just want us to say, okay, or that's fine. I get a lot of I'm pretty sure I know this is right, but can you just shoot me an email saying I'm right? Little CYA stuff.